My name is Michael Maddux, and I have been a probate attorney since 1996. Today, I'm going to go over some basics about probate process and procedure. First, what is a probate? A probate is a legal proceeding wherein a deceased person's estate is settled under the supervision of the superior court. How do we get a probate started, and how does this process work? In most circumstances, usually a person, a surviving spouse or adult child of the decedent, is appointed by the court. That representative marshals the assets of the probate estate and freezes them. That representative will also negotiate and pay creditors and provide an accounting to the court for a final distribution of the estate assets to the beneficiaries. Now, does all property have to go through the probate estate? Not necessarily. These are some common ways that probate is avoided. One way that probate is avoided is through beneficiary designations. For instance, on a life insurance policy, the holder of that policy may designate a beneficiary under that policy. When that holder dies, that beneficiary will receive his beneficial interest upon the death of the holder, and those proceeds do not need to pass through probate court. What about real property? How is real property usually passed outside of probate court? Many times, two or more persons hold title to what's called a joint tenancy deed. If two or more persons hold title to a property as joint tenants, when one of the joint tenants dies, the interest of the deceased joint tenant will pass to the surviving joint tenant by operation of law. Therefore, property can pass outside of probate court through a joint tenancy deed. This is a very common way that property is transferred outside of probate court. Finally, many of us know what a living trust is. If a living trust is properly executed and funded, the assets in the living trust will pass to the beneficiaries without the necessity of a probate proceeding. What if there is no will or there is no trust? If there is no will or trust, the decedent's estate will be administered in accordance with the California Probate Code. If there is no will or trust, a probate will have to be filed and the probate procedures will have to be followed. The probate court will determine what relatives will get the beneficial assets of the estate, and they will make the final determination as to how those assets are distributed in accordance with what's called the laws of intestate succession. How much does a probate cost? The average cost of a probate is usually only about $1,000. There is a filing fee of approximately $500. There is a $200 fee for publication in the local newspaper. And there is also various assorted process service fees. How long does a probate take to complete? A probate has many processes legally that must be completed before the estate can be finally distributed. First, probate has to be served on all the beneficiaries or heirs to the estate after it is filed. After everybody has service of process, the probate petition must be published in a local paper. After all the publication guidelines have been followed and the probate has been properly published, if the creditor's claims have been settled, the court may set a hearing on final distribution. And at that point, the court may consider distribution of the entire estate. That process would take no less than 6 months, and on the average usually takes about 1 year to complete. Thank you.